Hello, my name is Andrew Mestdagh, and I will be presenting to you my research and conclusions regarding situations where U.S. citizens house funds offshore. Specifically, I will be responding to the question, to what extent and under what conditions and circumstances may a U.S. citizen house funds offshore for tax purposes, and what are the specific legitimate tax purposes? Before I jump into the tax and legal reasons for holding funds offshore, I think it is important to define a couple terms in the issue question. Specifically, a U.S. citizen and offshore fund. An individual may be classified as a U.S. taxpayer based on their source of income, citizenship, or residence. For tax purposes, a U.S. resident is any person who is a U.S. permanent resident, as evidenced by holding a permanent resident permit, known as the green card test, or is physically present in the United States for 183 or more days in a year, physical presence test. Foreign persons who are not permanent residents of the U.S. do not file Form 1040. Foreign persons with U.S. source income file Form 1040-NR, U.S. non-resident alien income tax return. There are no questions on that form regarding disclosure of foreign accounts. In fact, it is presumed that the foreign persons will have foreign accounts. Also, companies created or organized in the United States are considered to be U.S. residents for tax purposes. As a general rule, if a U.S. resident has a combined total of more than $10,000 in one or more offshore financial accounts, the account or accounts must be disclosed annually. The term financial account includes money market funds, checking, demand, savings, pooled income funds, and time deposit accounts, as well as securities accounts. Not included are actual shares of a foreign company or various kinds of hard assets, such as real estate or precious metals. Now that you understand what an offshore account is to a U.S. resident, I will explain the process for reporting that foreign account. First, if a taxpayer files a Schedule B, interest and ordinary dividends, with his or her 1040 return, the taxpayer must check the box indicating that he or she owned or had control of a foreign account. The taxpayer must also file an annual report of foreign bank and financial accounts. This is more commonly referred to as FBAR. Control of an account is defined as U.S. persons who have signature authority or a financial interest in the account. The penalties for failure to disclose such accounts are severe. Willful failure to file an annual FBAR is a felony, punishable by up to 5 years in prison and a fine of up to $250,000. However, in many instances, U.S. residents aren't aware that they are breaking the law by not reporting their offshore funds to the IRS. In fact, the U.S. Treasury didn't create a form requiring U.S. citizens to declare foreign bank accounts until 2004. Two of the most common honest mistakes for not reporting offshore financial accounts are due to inherited accounts and immigration to the United States. For example, countless Jewish citizens chose to store a large amount of their wealth in Swiss bank accounts during World War II for fear of their funds being confiscated by the Third Reich government. As these ancestors have passed on, the U.S. citizens that inherit these accounts may forget to report the offshore funds to the IRS. Another honest mistake often occurs when people immigrate to the United States and maintain bank accounts in their home country. The new U.S. taxpayer may have the false perception that these countries are completely separate banking institutions with different reporting standards. While it is true that they may be separate banking institutions, the offshore funds must still be reported to the IRS. So now you're asking, what do I do if I haven't reported my offshore funds to the IRS in the past? Fortunately, the IRS has created a tax amnesty program known as the Offshore Voluntary Disclosure Program to encourage U.S. taxpayers to reveal their offshore accounts. The Offshore Voluntary Disclosure Program still penalizes U.S. citizens with fines on their unreported offshore funds. The primary benefit of the disclosure program is the protection from criminal prosecution. The main idea here is that tax evasion is illegal in the United States for all U.S. citizens. Taxes must be paid on income earned through funds at home and income earned with offshore funds. However, if a taxpayer complies with reporting requirements, it is not illegal to structure your portfolio to minimize the tax liability to the appropriate legal amount. In other words, a U.S. citizen has every legal right, pretty much, to minimize their tax burden, as long as they do it within the reporting framework. Some people may find it unethical to house funds offshore. Personally, I don't really have a problem with this. I think it's perfectly okay to maintain offshore accounts as long as the taxpayer reports the accounts to the IRS. Wealth preservation is a field that employs a lot of people in the United States, and many of them stay employed by advising clients on offshore tax mitigation strategies. In conclusion, a U.S. citizen may house funds offshore for legitimate tax purposes as long as the funds are reported to the IRS. Thank you.